There's a number of court matters that are worth your attention this Tuesday. One of them is unfolding in the High Court in Pretoria. That's where the DA is currently challenging the Employment Equity Amendment Act in its current form. Litigation there has just kicked off. Let's listen in.
And designated employers essentially covers the field, except for those that are indicated to you are excluded. And what it does, the significant difference is it now does not break it up into coloured, Indian, black, as you will see. It simply says designated group. And that covers all of them. It does, however, have a separate, right at the bottom, milady, percentage in each case for disability only, as you see. But otherwise, it sets the targets. Now, these targets, in terms of this document, milady, must be hit within 5 years. It's not explained how and how incremental that has to be. It's not explained what target you have to reach in year 1, year 2, etc. That would be a separate ground. It is a separate basis for attack because it is vague, milady, but that is not an attack we've taken. So I'm not going to press that. But I'm merely demonstrating, and this, it's crucial, as I say, to understand the case with reference to these targets rather, and the original targets that I'm going to return to in a moment. All of these, milady, are possible under this Act. Therein lies the problem. That is our fundamental problem. So it doesn't behove, our learned friends, and I don't, in fairness to them, understand that to be their approach. They don't try to say, well, look at this, these targets are fine, they're great. What's your problem? Because they can't. Because these targets are only here because of administrative, it's an administrative act. These can be pulled off the table tomorrow, milady, during the argument of this case, or next week, or next year. And the minister can bring along other targets. He can bring back the targets that he set initially. The targets he set initially, milady, as we plead in our founding affidavit, would have the consequence. So let's put this aside, because unless our learned friends make something of it, we're not going to address this further. This is merely illustrative of the problem. But the one thing that's crystal clear is all these targets have to be hit. And if they're not hit, milady, you can't do business with the state unless the minister, once again, in his gift, milady, decides that he's going to excuse your non-compliance. And it's crucial that you understand that distinction is borne in mind. Understandably, our learned friends argue, because we know what this case is about. This case is about flexibility. Whatever the state does, government does, to achieve an object that we all agree with, broad representativity of the population, it may not cross the line, milady, it may not cross the impermissible line between setting targets or goals which you hope to achieve in a structured, rational manner, and setting targets that are so rigid or so rigidly applied that they constitute a quota. That is not constitutional, primarily because of the effect it has on the dignity of those affected by the imposition of those quotas. So those principles are the general principles at play in this case, and we all seem to subscribe to and understand. But our argument, milady, is that the difficulty that government faces here is that here's an example of what they can do. So we set this aside, but if you go then back, milady, to 234, which is where I was earlier, the initial draft targets. This is another example of what the minister can do. They both are permitted in terms of this legislation, and therein lies the problem. So our challenge, DA's challenge, is to the legislation. Incidentally, in our notice of motion, we ask it in terms which make it clear, milady, that the target is not the particular
legislation,
subordinate legislation or targets that have been promulgated in any particular case. They all, and that's why in 014, the notice of motion, we in para 2 want a declaration, if you're with us, milady, and you declare the Amendment Act unconstitutional and invalid, whether in its entirety or separate parts of it, then as a consequence of that, we ask in 2 that any enactments promulgated in terms of 15A be declared unconstitutional and invalid. And that would follow, we say, automatically, because if 15A is not there any longer, it follows any enactment in terms of 15A must fall.
But is it the entire Act, the Employment Equity Amendment Act, that you want this court to declare unconstitutional, or only the sections that you made reference to in paragraph 1 of the notice of motion?
Thank you. For clarity's sake, Milady, if we correct on the tagging, then on the authority of Tongwane, paras 109 and 110, I believe, then the natural consequence of the incorrect section being used is that the entire Act, the Amendment Act, is unconstitutional and invalid. So that's a natural consequence if you're with us on the tagging. If you're not with us on the tagging, and we get to the merits of the challenge, lady, then it's only those sections that we ask, not the entire Act, but only those sections that we ask to be declared invalid. And it is, milady, it is, Section 15A is one of them, and we submit that 15A, if it goes, then any enactment in terms of 15A must obviously go as well.
Yes.
So there's no discrete and separate attack on the content of, well, we say the targets speak for itself. Milady, can I just make one last point about, and we've pleaded this in our filing affidavit, and perhaps I could just take you to that. And this is apropos, milady, the initial draft targets, which was all we had to deal with. As you know, the new targets were only promulgated after our heads were filed. They were promulgated in April of this year, milady. Long after pleadings closed, long after our heads were filed, which is why they're not dealt with. But can I take you to what we said to demonstrate, milady, why this legislation is offensive and what its ability is? Because therein lies the point. So our learned friends can't wriggle out of the problem, milady, by saying, well, there's nothing particularly wrong with this version. What's wrong with this version? Wrong question, milady. The correct question is, what can the minister do in terms of Section 15A? And if the minister is given an open book and the minister can cross the line from constitutional to unconstitutional, then Section 15A is unconstitutional. That is the DA's argument. And here's what the minister can do in terms of 15A, because the minister promulgated these draft regulations, which are DA1 to our papers. In para 56 of our founding affidavit, we say that. And I just want to see whether I can locate the table. Okay. In paragraph 56 of our founding affidavit, we say the following: the draft targets illustrated the point.
Just give me a minute to get there. What is the page reference?
223, case lines.
Thank you.
So, in our challenge, milady, to the legislation, you find that beginning at 221, we say it provides for a quota that sets rigid targets that must be complied with. I will return to that, milady. Ground 2 at 222, it otherwise violates Section 9. We there set out that ground. And we say that in 52, even if the impugned scheme is not a quota, it is nevertheless disproportionate and unconstitutional for the following reasons. First, it replaces the system. I've addressed that. It required every employer to formulate and implement an equity plan tailored for that employer's unique staff complements, operational needs, and the labour market it faces, with a one-size-fits-all mandatory targets that are the same for every employee in a particular sector and region, regardless of how differently situated they may be. The reality is that different employers will have different employment needs, face different labour markets. One employer might need electricians, another might require coders, another fitters and turners. Section 15A permits the minister to lump all of these employers together and force them to hire the same specified ratio of various race and gender combinations, which is what it does. Then we say, second, the impunity scheme has the potential to create an absolute barrier to employment or advancement for members of particular racial groups in a particular area. This is fundamental to our challenge, lady, this second point. And then we elaborate on it, we say the following. The draft targets illustrate a point. Posit X, an Indian woman falling within the skilled category in the financial and insurance sectors category living in Gauteng. That you find, milady, that we are referring to, you find at 0243. So if you go to 0243, financial and insurance sectors, you go to Gauteng, milady, and you go to skilled, where's skilled? Oh, skilled, D is skilled. So it's the right-hand block, milady, and you run down to Gauteng, female, and you run across. You will see I, Indian, is 1.9%. Is that correct? Yes. So, in terms of that target, milady, and you'll see this from these targets, and this is how these targets worked, or were conceived to work, milady. If you were a female in Gauteng working in the financial services sector and you were in the skilled category, your employer could only employ, milady, if you were a coloured female. 1.2% of the workforce could be coloured female. And Indian, milady, female, 1.9% could be Indian female. So that is how these targets were conceived in terms of 15A, milady. And we say the following about that in para 56. The draft targets applicable to designated employers operating in Gauteng would prescribe that a minimum of 82.3% of the workforce of any designated employer must be African, a minimum 2% must be coloured, a minimum of 11 must be white, a minimum of 1.7 must be Indian men. That adds up to a collective minimum of 97.4 for all of the race and gender groups other than Indian women, and thus an employment ceiling of 2.6% for skilled Indian women in the financial and insurance categories in Gauteng. It follows that it would become exceedingly difficult for X, an Indian woman, to find a job in Gauteng. She must find a designated employer that has not hit its very low Indian women ceiling, that needs her particular set of skills within reasonable proximity of where she lives. If she cannot do so, she must move elsewhere to find a job. And we go on. She could only really move to KwaZulu-Natal to improve her chances, given that this is the only province in which the Indian women's ceiling is higher than it is in Gauteng. In every other province it is lower. And the deponent says, I do not have to belabor the point that it is an exceedingly odious echo of our history for government policy to effectively require Indian people to move to KwaZulu-Natal to look for work. Now, my lady, that is the nub and the crux of the case. The minister's ability to set these targets, wherever they're set, my lady, that's not the issue. But to set targets that are going to apply across the board in every case, and the only out is if you are required, is for an employer to come along and say, well, I couldn't comply because of this and this reason. And then the minister can excuse your non-compliance. But we say that is not the same at all, my lady, as an act that doesn't impose unreasonable and unconstitutional burdens. All that does is that it's left to the minister in his gift to relieve you of the consequences of not complying with the minister's targets. And that is no answer to whether the targets are offensive or not. So that essentially, my lady, is the nub and the thrust of our complaint. The targets that are set in this case, the targets that may be set, given the minister's broad, unqualified powers now introduced in terms of 15A, permit, my lady, they are unconstitutional for the reasons that we've advanced in our papers and our heads. And they, we submit, cannot withstand scrutiny. They do not comply with the nuanced and flexible standard that the Constitution requires. That by way of a rather long introduction. I've got 15 minutes. I'm now going to go on to the first substantive issue, milady, which is the tagging issue.
Yeah, I think
Unless
so.
the court has any questions.
No, I think so. You can proceed.
As the court wishes. So you know the tagging issue, milady. It's the question that arises is, should this have been tagged as a Section 76 bill as opposed to the Section 75 bill? The test, and it seems we are all in agreement about what that test is, milady. And perhaps I can just take you to where the DA deals with this in its founding affidavit. We deal with it at 0228, milady. Ground 5, the incorrect tagging. And in para 74, we make the contention that it must be tagged and processed in terms of Section 76 if it affects, in substantial measure, any of the functional areas in Schedule 4 of the Constitution. It's common cause in this case, milady, that it was not tagged as a 76 bill, but as a Section 75 bill. And we say in para 75, given how broad and intrusive the impugned scheme is in respect of the economy of each province, the Amendment Act affects in substantial measure at least the following functional areas in Schedule 4, and we then list them, milady. Agriculture, airports other than international, national airports, casino, gambling, it's health services, goes on. And that's the case, that it substantially affects those functional areas in Schedule 4. Now, the parties don't seem to disagree, milady, that the definitive case, the dispositive case in this regard is Fungwane, of the Constitutional Court, that both parties have relied on. Fungwane, milady, has been uploaded to the authorities. It is to be found at 12-1307. 12-1307. Could ask the court whether you have that, milady.
I must still get there. Can you give me the page reference?
12, milady, 1307 is where the case begins.
Thank you.
12-1307. You have it, milady?
Yes, I have
Could I
it.
ask you to go to 12-1328, milady, para 49. The applicants there refer to as the communities, milady, and this was legislation, the Communal Land Rights Act, referred to in judgments Clara. In para 49, the court, this was a unanimous judgment by Noble CJ, as he then was. The communities contended that Clara should have been classified as a Section 76 bill because it affects the provinces. They relied upon the decision of this court in Equitable. They submitted that in Equitable, this court formulated the test for the classification of bills when it held that, I quote, a bill whose provisions in substantial measure fall within a functional area listed in Schedule 4, stop quoting, must be dealt with under Section 76. They submitted that the provisions of Clara in substantial measure deal with indigenous and customary law and with traditional leadership, which are functional areas listed in Schedule 4. In its written argument, Parliament contended that the test for tagging a bill was the substance of the legislation, which was referred to as the pith and substance test. The phrase pith and substance is borrowed from other jurisdictions and refers to what we term the substance, the purpose and effect, or the subject matter of legislation. The purpose and effect test was developed by this court to determine whether the National Assembly or provincial legislature has the competence to legislate in a particular field. Based on this test, which Parliament contended should also apply to the process of determining the manner in which a bill should be tagged, Parliament submitted that the pith and substance of Clara was land tenure. Any provision of Clara that deals with indigenous law or traditional leadership, matters listed in Schedule 4, is incidental to land tenure. These provisions were irrelevant for the purpose of tagging Clara. And then the court goes on in paragraph 52. However, in response to questions put to counsel for Parliament in the course of oral argument, there was a noticeable shift in Parliament's position. Counsel for Parliament accepted that there is a difference between the test for determining legislative competence and the test for determining how a bill should be tagged. This case, Milady, deals with the second, not the first. He also accepted that if a substantial part of a bill is concerned with the functional area listed in Schedule 4, then the bill falls to be classified as a Section 76 bill. I maintain that no substantial part of Clara affected the provinces and that Clara was correctly tagged as a 75 bill. The argument suggests that in tagging a bill, Parliament looks not only at the substance or purpose and effect, but also at the provisions of the bill in order to determine whether any of its provisions affect a functional area listed in Schedule 4. And then, from paragraph 55, the Constitutional Court deals with the proper test. It says that liquor bill involved a bill introduced in Parliament. It dealt with as a bill affecting provinces in terms of 76. And then the Western Cape province in this case did a bit of a cynical, it's been described in another case, I think, Judgment Law Rogers, did an about turn, and it suggested that the legislation should have been dealt with under Section 75, and based on an argument by the Minister, and not Section 76. But be that as it may, the court in paragraph 56 says the following, lady. In resolving which section applies, 75 or 76, the court said in resolving this issue, the heading of Section 76, what's now referring to its previous judgment in equitable, this court held the heading of Section 76, namely ordinary bills affecting provinces, provides a strong textual indication that Section 76(3) must be understood as requiring that any bill whose provisions in substantial measure fall within a functional area listed in Schedule 4 be dealt with under Section 76. It went on to hold that whatever the proper characterization of the liquor bill, a large number of provisions must be characterized as falling within such a functional area, more particularly the concurrent national legislative competence in regard to trade and industrial promotion. And then, accordingly, once a bill falls within a functional area listed in Schedule 4, it must be enacted in accordance with Section 76. And then there's some debate as to whether, in saying that, liquor bill was purporting to lay down a test, and the court deals with that, milady, in 58. And here is the definitive statement of the law and the ratio of Kongwana, milady. The contention of the community is that the statement whose provisions in substantial measure in liquor bill formulates the test for determining the procedure to be followed in enacting a bill must, in my view, be upheld. What matters for the purpose of tagging is not the substance, and this is crucial, milady, because of an argument that Parliament raises in its heads of argument and in its answering affidavit, which with respect to it is wrong, based on this passage. What matters for the purpose of tagging is not the substance or the true purpose and effect of the bill. What matters rather is whether the provisions of the bill, in substantial measure fall within a functional area listed in Schedule 4. This statement refers to the test to be adopted when tagging bills. This test for classification or tagging is different from that used by this court to characterize a bill in order to determine legislative competence. That would involve the determination of the subject matter or the substance of the legislation, its essence or true purpose, etc. And the court repeats that in 59, and then in 60, and this is where Tongwane refutes an argument raised by Parliament in its answering affidavit, and we believe that it persists within its heads. Tagging, it says the test for tagging must be informed by its purpose, the purpose of the tagging. And our learned friends put a lot of emphasis on that, but we submit that emphasis is misguided. I'll deal with that in reply. What's important for the moment is this. Tagging is not concerned with determining the sphere of government that has the competence to legislate on a matter. So to the extent that Parliament, in its answering affidavit, my lady, you find that at, you don't have to go there, I just want to read this to you because it demonstrates, we submit the error with respect on their part. In para 21 of their answering affidavit at 414, my lady, after explaining why we are wrong, they say, provincial legislatures have no power to pass legislation of the foregoing kind. In other words, the Amendment Act legislation. They say provincial legislatures can't pass such legislation, and that's a reason why this cannot be legislation affecting the provinces inasmuch as it falls within the functional area in Schedule 4. But those obviously are distinct requirements. The fact that the legislation could not be passed by a provincial legislature is irrelevant, as Tongwane is saying here. The question is not the competence of a legislature. And that you found in 60. And then, crucial to this case is the concluding statement in the final sentence in 60, where after stating the test again, the court says the following: whether the matter is to be dealt with or how it's to be determined in terms, how it's to be tagged, my lady, depends on the following, depends on whether it affects the provinces. The more it affects the interests, concerns and capacities of the provinces, the more say the provinces should have on its content. And that is the approach that the Constitutional Court endorses and requires. So the test, my lady, is does it fall within a functional area? Does it substantially, let me be accurate, my lady, and use the wording of the Constitutional Court. The test, my lady, is, do the provisions of the legislation, in this case the amendment, in substantial measure fall within a functional area listed in Schedule 4? And as the court says, this statement refers to the test to be adopted. So that is the test. Do the measures in substantial measure fall within a functional area listed in Schedule 4? That is the test in Tongwane laid down in para 58. That's the ratio of the judgment. That's given further content by what you see, my lady, in both para 59, the concluding sentence, i.e. do they substantially, the provisions substantially affect functional areas listed in Schedule 4, and then the final part of para 60, my lady, whether it affects the provinces. The more it affects the interests, concerns and capacities of the provinces, the more say the provinces should have. Now, if one looks, my lady, with respect at the legislation here, we submit that quite clearly it falls, as we pleaded, within a functional area listed in Schedule 4. In our heads of argument, my lady, at para 45, we've in fact set out a table which indicates 0728, my lady, is the heads of the table. The table you find at 0728, my lady. We set out the extent to which the Schedule 4 competences are coterminous with an overlap with the sectors that may now, my lady, be dealt with in terms of Section 15A, with reference, and that are dealt with, Melody, in the numerical, the targets that we've identified, referred to. So there you would see, Melody, that agriculture, for instance, appears in both cultural matters, education, health services, etc. So in all those sectors, Melody, which are now subject to 15A, and which are at the same time functional areas within Schedule 4, the Minister may now come along in terms of this legislation, the Amendment Act, Melody, and as we've indicated before, contrary to the approach adopted before, where every employer would generate its own equity plan and that would be carefully constructed on the basis of its own considerations, the Minister now comes in with a top-down numerical goal, Melody, which can be more or less egregious, but it's all at administrative, it's all within the Minister's power. The Minister can set these targets. There's no constraint on how he should set them, and that is the nub of our challenge. No constraint on how the targets are set. You can set targets, Melody, which are specific to individual race groups. You can set general targets for designated groups, as is now done. You can have regard or not have regard, Melody, to the different demographic makeups of the provinces, which is not done, and that's a separate ground of attack. When we get to the substance, it's not done with these numerical targets, precisely because they're not based, Melody, on, or they're not specific to different provinces. And what the Minister may do in terms of the amendments is to set these targets.
All right, once again, live visuals coming to you from the High Court in Pretoria. That's where the DA is advancing its case against sections of the Employment Equity Amendment Act. The party essentially arguing that a section of that piece of legislation gives the minister too much powers, which is not in line with the Constitution. We'll take you back to the litigation inside that courtroom.